The Ohio and Indiana Bar Associations require we give information about the attorneys on the show. Today with us, Stephen Crow with Crow and Welch in Milford, and Don Moore, the Moore Law Firm in Cincinnati. You can get all that information at fox19.com. Click on Moore Law, and of course, you can see all our other shows. So, isn't that great? And you had some information you definitely wanted people to hear about today.
Well, I did. I think it's important. We have cases oftentimes where people are involved in an injury case, and as a result, they get behind, they can't pay their bills, and bankruptcy may be the option. And so I have a little I guess, list here of things to consider. Number one, you've got to list a personal injury case in a bankruptcy. Number two, workers' compensation claims are exempt. However, the bankruptcy lawyer needs to know about that, because they may be a consideration even though they're exempt. And then with respect to the pain and suffering, those claims are not exempt. But Steve, I understand that there is a certain amount that a person can actually take even though it's not exempt. Is that right?
That's correct, Don. It's $20,200. And additionally, you can exempt a claim up within that framework, within that amount of money, for your future lost wages that may be awarded to you as well.
So when you have a person who just can't work and they're not able to keep up with their bills, and it's going to be extended or perhaps even permanent, but they have a potential settlement or judgment that may come their way, they can still get help from a lawyer who handles bankruptcy.
They certainly can.
And you're doing so well today, and I thought it was only fair to mention that you've got prior television experience, right?
Don, that's correct. I was on Uncle Al's show twice.
Twice you got invited back.
Yes, I did.
And I'm going to guess that was a few years ago.
It was a lot of fun. Yes, no, very few years ago.
My sister-in-law did not get back. She bit Uncle Al, so that was her one and only experience.
All right.
Let's get back to the phones here. We would like to talk to Tanya in Cincinnati. Tanya, you have a question about some student loans you're trying to pay off?
Yes, I have multiple student loans, and I only get paid $9 an hour, and I don't think that I'll ever be able to pay them off.
That's a lot of people have that problem.
It's a very large problem. We're seeing it extensively right now. About the only thing you can do in those situations, student loans under the bankruptcy law are not dischargeable in a Chapter 7 case unless you can establish a very great medical hardship, a very hard threshold to meet under the case law. But oftentimes what we're able to do is you can try a Chapter 13 in which you can restructure all of your other debt so that you're then able to meet your student loan payments. Okay. It gives you some time and some breathing room maybe to improve your job situation or your income.
So there is help?
There could be help, yes.
Okay, good.
Okay. What about, though, who suffers? I mean, when somebody is filing bankruptcy, I mean, all the creditors, I mean, if we take away, say, student loan, I mean, there has to be, somebody's not getting paid, or I don't understand exactly how that can happen, and, businesses still function. And
well, I'm sure that that there's a hierarchy, that the creditors get paid under the bankruptcy law. The secured creditors get paid the value of their collateral. The same would be for your home, but the unsecured creditors sometimes don't get paid in full. And I would imagine that perhaps they build that into their cost of doing business.
Okay.
And one of those might be IRS, and I think Melissa's got a question about that, right?
Is that right, Melissa? Go ahead.
Yes, ma'am. Good morning to everyone. I just wanted to know, can you include the IRS in a bankruptcy?
You can. In a Chapter 7 case, you might be able to discharge your tax liability if those taxes are more than 3 years old from the date that the return was due. That's kind of a general law. There are some exceptions depending upon whether you've experienced any audits or anything along those lines. And also in a Chapter 13, you're allowed to attempt to repay any debts in a Chapter 13, including Internal Revenue Service, if they don't fall within that 3-year period of time. Additionally, by filing a bankruptcy or a Chapter 13 specifically on tax liability, you also stop the penalties and the interest that continues to run on that tax.
Okay.
With respect to the 13, where you're working it out to try and pay people back, can you do that without going through a Chapter 13?
It's very difficult because there are some credit counseling provisions in the Ohio Revised Code that may stop creditors from taking action, but those provisions don't have the same full force and effect that the federal bankruptcy law has. So the federal bankruptcy law really provides a lot more protection.
And how about those credit counseling companies? Are they worthwhile?
I think they're worthwhile if the debt that you are experiencing isn't overwhelming. If it's a small amount of debt that maybe you could pay off in a year, 2 or 3, I think that's worth considering. But when the debt becomes overwhelming or it would exceed a 2 or 3 year payment period, then you need some more help with a Chapter 13 or a Chapter 7.
Okay. All right, let's talk to Marty in Mount Carmel. You have a question, I believe, about whether Social Security and disability factors into bankruptcy.
Yeah, how you doing today?
I'm doing good. How are you?
All right. Yeah, if you're on Social Security disability and you run up a credit card and you can't pay them, can the creditors take money out of your check that you get monthly?
No, they can't. The Ohio laws exempt and allow you to retain any Social Security benefits that you receive. So no, they can't directly seize that. But the problem you may run into is if you deposit those funds into a checking account, and if you then commingle or put other funds into the checking account, the creditor might be able to seize the checking account. So while they can't seize the Social Security funds themselves, if you place it into a checking account and don't keep that account as solely Social Security, it could be seized.
So is the idea keep it cash or have a separate account for your SSDI?
I would have a separate account for the Social Security income, and the only thing that I would put into that account would be the Social Security.
Before we go to our next caller, one of the things that I wanted to make sure we got in, because I think everybody cares, is what does a bankruptcy cost a person to file, and what's a lawyer, what's a filing fee cost?
The court costs for a Chapter 7 case are $306. For a Chapter 13 case, $281. The attorney's fees run, I would say, from a low of $750 all the way up to $1,500, $2,000, depending upon the complexity. The fees in a Chapter 13 case are subject to review and approval by the bankruptcy judge and the bankruptcy court.
Okay.
So there's kind of a standard fee that they approve, and again, that's up to the court.
All right, very good, thank you.
Okay. All right, let's check in very quickly. We have one last call we can get to. Cherie in Cincinnati. Cherie, go ahead.
Yes. My question is, why is there a difference between Chapter 7 versus Chapter 13 on when your bankruptcy is dismissed, like 7 years versus 10 years?
Can you give us a quick answer on that?
The quick answer is that's governed by the Fair Credit Reporting Act and not necessarily the bankruptcy law. So they just make that distinction under the Fair Credit Reporting Act.
Okay. All right, Stephen Crow, thanks for joining us today.
Thank you very
Steve,
much.
thanks a bunch.
Thank you
And
again.
Coming up next week, Don?
Next week, I'm out of here. It's going
Well, then I'm not coming.
Dan's going to be taking my place. It's going to be elder law.
All right. Well, we'll be looking forward to that, although we'll be looking forward to 2 weeks from now when you're back.
All right. Thanks.
Please join us again next Monday morning at 9:30 for more law. In the meantime, have a great week.